Welcome to Family Law Talk. Family Law Talk. Presented by Kirk Stange of Stange Law Firm, PC. Stange Law Firm is a multi-state family law firm. Now, here's your host, Kirk Stange.
Welcome to Family Law Talk. We have an interesting topic today. The topic is what's a motion to compel? In the episode today is based on an article on our blog, familylawheadquarters.com, dated December 17th, 2024, and the title of that article is What's a Motion to Compel in Family Law Litigation? So as a follow-up to the episode today, go on over to familylawheadquarters.com and read the article on the same topic for more information. But let's go ahead and jump into the topic at hand today. Obviously, divorce and family law litigation can be quite difficult. When a judge has to make a decision regarding child custody, child support, spousal maintenance, property division, and other issues in the family court, it can be really overwhelming for many individuals. The concept that one judge is going to decide their case. But the reality is in terms of presenting a case in the family court, discovery can be an integral part of that process. And really as part of the process, in discovery, what individuals are attempting to do is learn the other side's story, get the evidence that the other side has at their custody and control that they intend to present in court, and that way there's no surprises. An individual is able to foresee what the other side's argument is going to be, get any of their evidence, and that gives an individual time to come up with counter-arguments or the ability to assemble and put together evidence and exhibits to really contradict what the other side's going to present in court, okay? And when we talk about discovery, there's lots of different types of discovery, if you will, that individuals could utilize in family law litigation. But two of the big ones are called interrogatories and requests for production, all right? Interrogatories are written questions that one party serves on the other side, and they have to answer these questions, okay? And the nuances can vary by jurisdiction. In some jurisdictions, an individual can be limited in terms of the number of interrogatories they serve. Sometimes they have to answer the interrogatories first before the other side is required to respond to them. But these are written questions, okay? It could be background information like employment history and how much money somebody's making to, questions involving child custody in terms of what a party is requesting in court, any evidence that they have to really substantiate or back up their request. There could be interrogatories involving, marital property and debt, like how much money somebody has in X, Y, and Z account. Really, it's just the possibilities are really endless, if you will, okay, in terms of interrogatories. And then requests for production are another important tool in the discovery process. And in requests for production, parties are specifically asking for documents and evidence from the other side, okay? It could be tax returns, could be paycheck stubs, it could be daycare records, it could be titles to vehicles or real estate, could be 401k statements or pension statements, could be text messages, emails, photos, videos, other evidence that a party thinks is going to be important in the case itself. And again, the rules are kind of the same. In some jurisdictions, there might be a limit on the number of requests for productions that can be propounded on the other party. Sometimes a party has to answer their request for productions first before the other side's required to respond. And obviously in other jurisdictions, there can be other nuances as well. All right. But once these are served and once they're served appropriately, then there's typically a time deadline in which the other party has to respond. And again, this is going to vary based on jurisdiction again. But Missouri, where I've predominantly practiced, it's 30 days. That a party has to respond to discovery served upon them. Certainly talk to a lawyer who's licensed and competent to practice law in your jurisdiction to find out what the time deadlines are in your jurisdiction. Okay, this can vary by state, and sometimes it can even vary based on the locality. But look, what ends up happening is sometimes a party doesn't respond at all. All right, so if it's a 30-day deadline, they just don't respond. In other instances, a party may respond, but the responses are incomplete, let's say, right? Not everything that they turned over. Sometimes a party might object to certain discovery served upon them based on evidentiary reasons, so they don't respond at all. And so then really the question is, in any of these scenarios, whether they haven't responded, whether the responses are incomplete, or whether the other parties objected, the question is, what do you do, or what does your lawyer do to get the other side to respond? And that's what a motion to compel is, okay? A motion to compel is a motion. It's filed in court, and then it's typically noticed for hearing in front of a judge. And the idea is to get a specific court order from the judge ordering the other side to respond to the discovery itself. Okay, if a party hasn't responded at all, these motions can be a tad bit easier because you just say, "Hey, judge, they haven't given us anything." If you're dealing with incomplete responses, then oftentimes this can be a little more nuanced in front of the judge, where lawyers got to explain what's missing, what wasn't turned over, and then obviously if there's evidentiary objections to the discovery itself, and evidentiary objections can be, countless possibilities, but it could be relevance, it could be that it's based on hearsay, that it's not limited in time and scope, and so on down the line. But in these circumstances, a judge then has to actually look at the discovery that was issued, has to then look at the objection, and then typically has to go through each of the interrogatories of the request for productions one by one. And in theory, a judge could overrule the objection, or they could sustain the objection. And then, at the end of the day, if the judge finds that, more information needs to be turned over, either in terms of the interrogatories or the request for production, then a judge sets a time frame, typically in terms of when that needs to take place by. And then at that point, the hope is that the end, the other side responds to the discovery and the evidence is turned over as required. Look, in some circumstances, a party still doesn't respond even after being, ordered to do so by the judge, and that can require an additional motion to compel, or maybe even a motion for sanctions if a party, believes the other side's just not acting in good faith, okay? Obviously there's other nuances to motions to compel as well, so speak to a lawyer in your jurisdiction, but oftentimes parties are to make a good faith effort at attempting to resolve the discovery dispute without filing a motion to compel. So oftentimes, letter is sent first that says, "Hey, you're late. You didn't respond to the discovery. Let's talk about it, or give me your responses. And if you don't by X, Y, and Z date, then we're going to file a motion to compel." And this is called a good faith letter, if you will. And oftentimes, what courts are looking for is that attorneys can get on the phone, communicate with one another, and work through these discovery disputes without the need of the judge being involved. But look, sometimes that's just not possible. And so motions to compel can be very important, particularly in cases where there's, information you need, evidence that you think is important, and you don't have it. And so, having your lawyer file a motion to compel can be important. And in fact, in family law litigation is very, very common in something that happens quite often. So, it's important to have that discussion with the lawyer to make sure that the other side's not getting out of responding to the discovery that they're required to respond to in the case, okay? So that's what a motion to compel is. So definitely an interesting topic, one I wanted to cover. Is a follow-up to the episode today. Go on over to familylawheadquarters.com, read the article titled "What's a Motion to Compel in Family Law Litigation?" The date of the article is December 17th, 2024. That'll give you more information on this topic. But look, thanks for tuning in today. Stay tuned to our next episode of Family Law Talk coming up. Thank you very much.
Thank you for listening to Family Law Talk with Kirk Stange. Visit StangeLawFirm.com for more about today's topic, or to put Stange Law Firm to work for your family today. The choice of a lawyer is an important decision and should not be based solely on advertisements. Neither the Supreme Court of Missouri or Illinois reviews or approves certifying organizations or specialist designations. The information you obtained in this podcast is not, nor is it intended to be, legal advice. You should consult an attorney for advice regarding your individual situation. We invite you to contact us and welcome your calls, letters, and electronic mail. Contacting us does not create an attorney-client relationship. Please do not send any confidential information to us until such time as an attorney-client relationship has been established. Past results afford no guarantee of future results, and every case is different and must be judged on its own merits. Kirk Stange is responsible for the content. Headquarters, Office 120 South Central Avenue, Suite 450, Clayton, Missouri 63105. Kirk Stange is licensed in Missouri, Illinois, and Kansas.